Welcome to the All Rise Podcast Sunday Scaries. I'm your host, Christine, a civil litigator and personal mentor. Every Sunday, we'll tackle those dreaded Sunday Scaries together to demystify the practice of law and provide you with actionable tips and guidance to face your week ahead. So grab a cup of coffee, take a deep breath, and join me while we turn those Sunday Scaries into stepping stones towards your success. Let's get started. Welcome back to another episode of All Rise Mentors Sunday Scaries, where we help navigate through the stresses of legal life with actionable advice, encouragement, and of course, the desire to motivate to start your week strong. I'm your host, Christine Barker, and today we're talking about a topic that is actually very close to my heart because I just went through it, and that is trial. This wasn't my first trial, but it had been a while since I had gone to trial. It'd probably been, I want to say 2 or 3 years since my last trial. So whether you're preparing for your first trial or you're just looking to refine your litigation skills, there's no better teacher than the courtroom. It's true. Trials are intense. They're demanding. They're nerve-wracking. But they're also really powerful learning tools and experiences for us. Today, I'm going to share with you the 5 lessons that I recently learned from starting trial. Now, I say starting trial because I didn't actually finish. And I'll explain when I'm going through my lessons here, because a lot of them did come up. In fact, I had 6 trials that were supposed to start this month. 3, in fact, did start. One got continued. So, and all of them have kind of their different life lessons to them. So these are things that I wish someone would have told me before I walked into the courtroom for the first time. And I really hope that they will help you and help you be prepared and more confident and maybe even a little less stressed out when you're starting your own trial. So without further ado, let's dive into the lessons. So lesson number 1. And this one is honestly so key. And I think a lot of times we forget it because we're so stressed about preparing for the trial. And that is settlement is always on the table. When the realities of the pressure of sending a case to a judge or to a jury becomes imminent, that's when both sides often take a really hard look at their case and at their facts and their risks and rewards of trying to settle a case versus going to verdict. Courts stress this a lot too. A lot of courts will send you to a mandatory settlement conference right before you start trial, just to see if there's any last minute, ways to try and resolve the case. Because it's true, settlement is the only time for the parties to have full control over the outcome of their case. Once you start trial, once you send it to a jury, once you send it to a judge, and they make the decisions, it's out of the party's hands. So it is really important to just keep that in the back of your mind. Settlement is always on the table. Here's some takeaways from kind of a recent case of mine. So we're preparing for trial. We're doing our pre-trial documents. I'll talk about those in a minute. And the other side's not prepared. They weren't ready. They hadn't worked up their case. And it really put us in a great position to negotiate a better deal for our client, a better strategy. And in fact, we wound up settling, I think that one, we settled at the final status conference, which is usually 1 week before our trial actually starts. We made a settlement offer to them then. I think we continued negotiations and settled a couple of days later. We had to go back to the start of trial, though, put the settlement on the record with the judge, and another party still hadn't settled. They wound up settling in the hallway after the court ordered them basically to a mandatory settlement conference. Go stand outside and see if you guys can work this out. And they were really close. So, never close the door on settlement discussions. Even when you're deep in trial prep, you might find that as the trial gets closer, the other side is more willing to make concessions. So you just need to stay open and flexible and remember that settlement is something that can be a win for both. It can be a win for your client. Like I said, it's the only time really that they have any control over the outcome of the case. Once it goes to the judge, once it goes to the jury, it's out of their hands. So never close the door on settlement. Lesson number 2, and again, this one came up recently as well. Remain professional at all costs. Litigation is inherently adversarial, but professionalism is paramount. One lesson I did learn from one of my recent cases, as we were preparing for trial, the other side was just very difficult and was, berating, would call and just say mean things on the phone, and was very, very confrontational. And it was hard to stay professional when someone is berating you repeatedly. One thing that I did do with this particular opposing counsel is I said, we're not going to speak on the phone anymore. Everything that we communicate needs to be through email. So it's when you have to put things down in words, and you have to write them down in an email that potentially could be seen by a judge. People tend to be a little more careful with their words. Not saying there's not still keyboard warriors out there, and there are, but people are a little more careful with their words when it is going to be in writing. So one little key takeaway from that is, if you are dealing with a difficult opposing counsel, try, just letting them know, look, we're only going to communicate via email. And also make sure that you copy somebody else, like a partner or a colleague or somebody. Sometimes when you're emotionally involved, because they're being personal or being rude to you, it's hard to remain neutral and really keeping the client's best interest in mind when you're negotiating or just communicating with them. But here's the real kicker, and trials are cooperative in many ways that you don't expect. See, parties are required to work together, especially when it comes to submitting joint pretrial documents to a judge. So the courtroom really is no place for pettiness and egos, and you're going to get a lot of those in this practice. So as best as you can, remain professional in the face of adversaries. Just remain calm, composed, always act professional, no matter how tense things get. Your reputation as an attorney is as much on the line as your client's case. So just keep that in mind, because you will run into these attorneys again. The legal community is smaller than you think. Lesson 3. Start preparing early. It is more time consuming than you think. I cannot stress this enough. Start preparing right away. We have our case handling checklist that if you subscribe to our email list, I'll send you a free copy of, but it really does walk you through how to prepare for trial and how the litigation can start being that preparation for you right away. And if you're doing that, if you're constantly looking towards the end, what trial is going to look like, it's going to make the preparation when trial actually comes up a whole lot easier for you. Trial prep is long, it's detailed, it's often an overwhelming process. There's so much more involved than than just knowing the facts of your case. What documents are going to come in, what witnesses are you going to call, how are you going to present the evidence? But then on top of that, it's jury instructions, it's verdict forms. It's, like I said, that's a lot of cooperation with the other side. And if you've got a difficult opposing counsel, that's going to be more time consuming when you're having to do the joint documents. Trial prep is also a time where you're going to be refining your strategy over and over. It's one thing to have your witnesses have their depositions taken, read through a depo transcript, and think, okay, this is how they're going to present. A lot of witnesses have never been to trial before. So when they get up on the stand, they may freeze. They may forget what they're supposed to say. They may testify in a different way. So it's a lot of pivoting when you're actually in trial. So the earlier you can give yourself to have a little bit of that breathing room to do it right without burning out, without missing key details, without missing key deadlines. Think of it this way. The earlier you start, the more room you have to absorb the unexpected. And believe me, there are lots of unexpecteds to happen. Go right back to lesson 1. Settlement's never off the table. So while you're preparing for your trial and you're getting your pretrial documents in order, somebody's calling you saying, hey, let's go to a quick mediation, or I'm going to submit this policy limits demand to you. And now you've kind of have to drop everything, evaluate that, have lots of calls, have lots of strategy sessions. And if you didn't build in enough time for that, you're going to be up against yourself and up against deadlines and burning the candle at both ends. Unexpected things will happen, and it is going to be time consuming, regardless of how much breathing room you build in for yourself. Just know that going in. Nothing's gone wrong. Just know that going in. Lesson number 4, stay organized and don't be afraid to ask for help. Organization is the key, not just for the trial that you're preparing for, but for your other cases as well. The demand of trial prep can easily consume all of your attention, but you still have responsibilities to other clients, and some fires can start popping up on those other cases. So you want to make sure that you're paying enough attention to all of your cases. building in extensions for yourself, asking for those extensions, letting people know when you're going to be in trial, and then asking for help and coverage support. This is why staying organized is critical. Use a trial calendar or a detailed checklist to track your deadlines, to prep witnesses, for your court submissions, all of those things. I've put together a trial prep checklist and a deadline schedule. So again, if you want to subscribe to our email, I'll send you a copy of it. It really helped me stay organized, especially when I had all of these trials going on at once. Now, I will tell you, I was not trying every single one of them. So I did ask for help. So one of my trials, I asked one of my partners to step in and actually try the case for me. So I got everything ready for him, but he actually was going to be the one who stepped in and did the actual trial. That one wound up settling the day of trial. The day trial was supposed to start, that one settled as well. So, but then I had two other trials, one that I actually started, and then one that we trailed. So basically I went to court in both of those cases at the final status conference. And I told the judge, I'm in trial in another trial, and you need to let the court know what department you're in, what courthouse you're in, what department you're in, who your judge is, give them the case number, and then also let them know when the complaint was filed. And this is important because first in time, first in right. So if the trial, whichever case is older, that's the one that's going to take precedent and go, meaning start trial. And the other one will trail behind it, meaning that it won't start until the first one is completed, but it'll stay on the court's calendar, and you go in periodically, usually once a week, to let the court know where you are with the other trial so that they can plan on when the trial in that department is going to start. But using a trial calendar or something like this to track all of that is really, really essential, especially when you need to delegate and ask for help, because there probably are certain things that you, as you're preparing for trial or you're preparing with your partner, that only you can do. For example, if you took the depositions, it's probably best for you to do, a page line summary or a deposition summary. So you really can't pass that off to somebody else. If you're readily familiar with the documents, it might be best for you to be preparing the exhibit list instead of handing that off to somebody else. But if you've got a deposition in another case, that might be a good one to ask for somebody to cover for you. Or if you've got an appearance or a case management conference or something like that, those are things that you're going to want to delegate. Lesson number 5, and honestly, I saved this one for last because it really is that important, and that is build in enough downtime for your own mental well-being. This really is the most important one. Trial is mentally, physically exhausting, and burnout is real. In fact, the moment my case is all settled, and one case did get continued, I'll tell you a little bit about that. But the moment that all happened, I booked a trip. I was like, I got to get out of here for a weekend. Like I've got to go decompress somewhere. So the stress, the long hours, the emotional investment can take a really serious toll on your well-being, especially if you've got contentious opposing counsel. If maybe you don't have the best facts of your case and your client just really wants to try the case. And last minute settlements. And so you're kind of being pulled in different directions. So really building in and carving out that time to take breaks, schedule moments of decompression, whether it's taking a walk, grabbing a coffee with a friend, simply sitting in silence for a few minutes. I really started prioritizing my sleep. So for me, I work better in the mornings. So what I would do is I would build in time in the morning for me to get up early, go through my emails. It was really the time that I looked at my other cases, made sure nothing was falling through the cracks, delegated accordingly, so that during the, kind of business hours, I could focus, almost exclusively on the trial that I was preparing for. But a clear mind, a rested mind will serve you far much better than you driving yourself into the ground. So just try and build that time in for yourself. So I was going to tell you, two of my cases, three of them settled, two at the courthouse steps. Two settled, one got continued. And then the third one, and again, this is that pivot thing, because last minute things will come up. And facts changed in this case about 2 or 3 days before trial. So I went in on an emergency motion. In California, they're called an ex parte motion. Basically means that I'm going in ex parte, just one party, me going into the court, asking the court for something. And what I went in and asked the court was I wanted them to bifurcate the trial. And I want 2 trials, One, to deal with this new legal issue that just came up. And then depending on how that outcome, what the outcome of that first phase of trial, then to go into the regularly scheduled jury trial. So that motion was filed 2 days before my trial was set to start. I went in on an ex parte basis. The court continued my ex parte to the first day of trial and wound up granting the ex parte and allowing us to file a motion to bifurcate. So the court hasn't bifurcated it yet. They were intrigued by our argument, wanted to hear more about that. So the court then gave us a scheduling order and is reset our trial for something that works for the court so that he can hear this earlier issue. So, like I said, lots of things can change during a trial and you have to be able to pivot. So there you go, the 5 critical lessons I learned from starting trial this last week. Always keep settlement on the table. It's always an option. Maintain professionalism, even in the face of adversaries. Start prepping early. You never know when you're going to need to pivot. Stay organized, delegate if you need to, and protect your well-being. All of those things will serve you well the next time you have to start trial. So thanks for tuning into this week's episode of All Rise Sunday Scaries. I hope that you found these lessons interesting. If there are any other topics you'd like us to tackle, by all means, let us know. And in the meantime, don't forget to subscribe, leave a review, share this podcast, and we will see you all next time. Have a good one.